In this part, we shall discuss about two special types of contracts, that is, contract of indemnity and contract of guarantee. We shall understand meaning of the contract of indemnity and what are rights of a promisee in a contract of indemnity. Then we shall talk about contract of guarantee, where we will discuss meaning, various terminologies related with the contract of guarantee, what are rights and liabilities of the parties in that contract when a guarantee becomes invalid. And finally, we shall discuss what are differences between contract of indemnity and contract of guarantee. Let's first understand what is a contract of indemnity. Section 124 of the Contract Act gives us the meaning of contract of indemnity. The section says that a contract by which one party promises to save the other from loss caused to that other by the conduct of the promisor himself or the conduct of any other person, this contract is called a contract of indemnity. So any contract in which one party promises to save the other party from the loss which is being caused to that other party, this loss might be caused due to the conduct of promisor, the first party himself, or this loss may be caused due to the conduct of any other person. This contract is called a contract of indemnity. Say for example, A contracts to indemnify B against the consequences of any proceedings which C might take against B in respect of a certain sum of rupees 20,000. Here A has promised to B that if C takes any proceeding against B, then A shall indemnify the B against the loss which might be caused to B because of these proceedings. This is a contract of indemnity. Section 125 tells us what shall be the rights of a promisee under a contract of indemnity. In a contract of indemnity, promisee is a person to whom a promise to indemnify him has been made. What shall be the rights of this promisee? Let's see. Section says, in a contract of indemnity, the promisee, if he is acting within the scope of his authority, is entitled to recover from the promisor, from the person who has made a promise to indemnify him, the following amounts. Promisee may recover all the damages which he may be compelled to pay. He may also recover all the costs which he may be compelled to pay in any suit, and he can also recover all sums which he may have paid under the terms of any suit. Now let's discuss various aspects of another special type of contract, that is, contract of guarantee. Section 126 of the Contract Act gives us the definition of contract of guarantee. And it's a very simple definition. Section says that a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of default by the third person. So very simply speaking, contract of guarantee consists of a promise that the promisor shall discharge the liability of a third person. The promisor shall perform the promise made by a third person in case there is a default by the third person. Let's see certain terminologies which are used with reference to a contract of guarantee. The very first term which is used in the case of contract of guarantee is surety or guarantor. Surety or guarantor is a person who gives the guarantee. The person who gives the guarantee is called surety or guarantor. Then the person in respect of whose default the guarantee is being given, this person is called the principal debtor. And finally, the person to whom the guarantee is being given, this person is called the creditor. So there are three parties involved in a contract of guarantee: surety or guarantor, the person who is giving the guarantee; principal debtor, for whom the guarantee is being given; and creditor, in whose favor the guarantee is being given. A very important issue in a contract of guarantee is consideration. What is the consideration for the contract of guarantee? We have seen in earlier parts that normally a contract without consideration is void. However, for the contract of guarantee, section 127 says that anything done or any promise made for the benefit of the principal debtor is a sufficient consideration to the surety for giving the guarantee. So in this case, surety, the promisor, doesn't need any separate consideration. Whatever is being done for the benefit of the principal debtor, that is a sufficient consideration for the promisor to give the guarantee. Say for example, Mr. B requests Mr. A to sell and deliver certain goods on credit. A agrees to do so provided Mr. C guarantees the payment. C promises to guarantee the payment in consideration of A's promise to deliver the goods to Mr. B. This is a sufficient good consideration for promise of Mr. C. Section 145 of the Act creates a very interesting relationship between a contract of indemnity and a contract of guarantee. Section says that in every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. And the surety is entitled to recover from the principal debtor whatever sum he is rightfully paid under the guarantee. So a very interesting concept is being created by section 145, which says that in every contract of guarantee, a contract of indemnity is implied. It is implied that principal debtor shall indemnify the surety for whatever loss he may incur under the contract of guarantee. Now coming to the aspect of liability of a surety, section 128 says that liability of surety is coextensive with the liability of a principal debtor unless something else has been provided by the contract. Simply speaking, this means that the liability of surety is the same as the liability of the principal debtor. Say for example, Mr. A guarantees to Mr. B the payment of a bill of exchange by Mr. C, the acceptor. The bill is dishonored by Mr. C. Now Mr. A is liable not only for the amount of the bill, but he is also liable for any interest and charges which may have become due on it. So, again, the liability of surety is same as of the principal debtor. This is what has been specified by section 128. Section 129 creates a concept of continuing guarantee and says that a guarantee which extends to a series of transactions This guarantee is called a continuing guarantee. Say for example, Mr. A, in a consideration that Mr. B will employ Mr. C in collecting the rents of B's property, promises to Mr. B to be responsible to the amount of rupees 5,000 for the due collection and payment by Mr. C. Now this is a continuing guarantee, shall extend to a series of transactions. That's why this will be treated as a continuing guarantee under section 129. Issue comes up related with the continuing guarantee, that how and when a continuing guarantee may be revoked. First situation is given by section 130, which says that a continuing guarantee may be revoked at any time by the surety by simply giving a notice to the creditor, and this guarantee shall stand revoked so as to the future transactions after this notice. Another situation for revocation of a continuing guarantee is given by section 131, which says that the date of the surety operates as a revocation of continuing guarantee so far as regards the future transaction. Of course, the contract may have a different provision, but normally the date of a surety results into revocation of a continuing guarantee. Now let's understand what are various modes by which a surety gets discharged from its liability under the contract of guarantee. Just to recall, surety is the person who has given the guarantee. Let's see how he gets a discharge from its responsibility under the contract of guarantee. First mode of discharge of surety has been given by section 133, that is discharge of surety by variance in terms of contract. Section says that any variance made without the surety's consent in the terms of the contract between the principal debtor and the creditor shall discharge the surety so as to transaction subsequent to the variance. Simply speaking, it means that without the consent of surety, if principal debtor and creditor changes the terms and conditions of their original contract, this result into surety getting discharged so as to subsequent transactions from this variance. Say for example, Mr. A becomes surety to Mr. C for conduct of Mr. B as manager in C's bank. Subsequently, without the consent of A, B and C make change in the contract of employment. Subsequent to this, due to B's conduct, C, the bank, loses a sum of money. Here, Mr. A is discharged from his suretyship by the variance made without his consent, and he is not liable to make good these losses. Second mode of discharge of surety is given by section 134, that is discharge of surety by release or discharge of principal debtor. Section says that the surety is discharged by any contract between the creditor and the principal debtor by which the principal debtor is released, or by any act or omission of the creditor, the legal consequences of which that principal debtor is discharged from his liability. Say for example, Mr. C is supplying goods to Mr. B and A gives a guarantee to Mr. C in this contract. After this, C supplies goods to B and later on B and C enter into a contract by which B is released from his debt towards Mr. C. This shall result into Mr. A also getting discharged from his suretyship. The next mode of discharge of surety is given by section 135, that is, discharge of surety when creditor compounds with, gives time to, or agrees not to sue the principal debtor. This section says that a contract between the creditor and the principal debtor, by which the creditor makes a compromise with or promises to give some extra time or promises not to sue the principal debtor, this contract between the creditor and principal debtor shall discharge the surety unless surety also gives his consent to such contract. Let's move on to provisions dealing with rights of surety. Section 140 discusses about the rights of surety on payment or on performance. Section says that a surety upon payment or performance of all for which he is liable for, he shall get all the rights which the creditor had against the principal debtor. Simply speaking, after performing all for which he was liable under the contract of guarantee, a surety shall step into the shoes of the creditor and shall get all the rights which the creditor is having against the principal debtor. Another right of surety has been given by section 141, that is, right of surety to benefit of creditor's securities. This section provides that a surety is entitled to the benefit of every security which the creditor has against the principal debtor at the time when the contract of guarantee has been entered into, even if the surety knows about the existence of such security or he may not be aware about these securities, but still he is entitled to benefit of all the securities which the creditor was having against the principal debtor at the time when the contract of guarantee has been made. Section 141 further clarifies that if the creditor loses or without the consent of surety parts with such security which he was having at the time when the contract of guarantee has been made, the surety shall stand discharged to the extent of value of security so lost or parted with by the creditor. Now let's discuss another aspect of a contract of guarantee, that guarantee when it becomes invalid. The first case in this regard has been given by section 142, which says that a guarantee obtained by misrepresentation is invalid. Section says that any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction, this guarantee is invalid. So wherever a misrepresentation has been made by the creditor or it has been made with his knowledge and assent, and this misrepresentation relates with a material part of the transaction, this will result into guarantee getting invalid. It has been provided by section 142. Section 143 talks about a guarantee which is obtained by concealment, and then section says this guarantee is also invalid. The section provides that any guarantee which the creditor has obtained by means of keeping silence as to the material circumstances, this will be treated as a guarantee obtained by concealment, the creditor has not mentioned something which he should have mentioned to the surety, to the guarantor, the creditor has kept silence about a material fact related with the contract, and this will render the contract of guarantee as invalid. Section 144 discusses another situation where a guarantee has been given with a condition that creditor shall not act on this guarantee unless and until a co-guarantor, a co-surety, joins in. Section says that where a person gives a guarantee with a condition upon a contract that the creditor shall not exercise this guarantee, shall not act upon this guarantee unless another person has been included as a co-guarantor, as a co-surety. In this case, the guarantee is not valid if that other person does not join. And then there is a very important issue related with the commencement of the guarantor's liability. The law says liability of the surety arises as soon as a default is committed by the principal debtor. The creditor is not required to first sue the principal debtor and then come to the surety. The creditor can sue the surety directly without suing the principal debtor. And now let's see what are the distinctions between a contract of indemnity and a contract of guarantee. The very first difference is based on number of parties. In a contract of indemnity, there are only two parties, namely the indemnifier, promisor, and the person who has been indemnified, the promisee. As against this, in a contract of guarantee, there are three parties, creditor, principal debtor, and the surety. The next difference between a contract of indemnity and contract of guarantee is based upon extent of liability. In a contract of indemnity, the liability of the indemnifier, the promisor, is primary and independent. On the other hand, in a contract of guarantee, the liability of the promisor, the surety, is secondary as the primary responsibility, primary liability is that of the principal debtor. The next difference is from the angle of time of liability, when the liability shall arise in a contract of indemnity and a contract of guarantee. In a contract of indemnity, the liability of the promisor, the indemnifier, arises only on the happening of a contingency. Whereas in the case of contract of guarantee, the liability is already in existence, but it gets crystallized only when principal debtor makes a default. One more difference between the contract of indemnity and contract of guarantee may be seen with reference to the time to act. In case of contract of indemnity, the indemnifier, the promisor, is not necessarily required to act at the request of the promisee, the indemnified. However, in the case of a contract of guarantee, surety must act by extending the guarantee at the request of the principal debtor. It is only on the request of principal debtor that the promisor, the guarantor, the surety shall be required to perform his part of promise. And finally, there is a difference based on right to sue the third party. In case of contract of indemnity, the promisor, the indemnifier, cannot sue a third party for the loss in his own name, as there is no privity of contract between this indemnifier and that third party. On the other hand, In case of contract of guarantee, surety, promisor can proceed against the principal debtor in his own right because he steps into the shoes of the creditor. He gets all the rights of a creditor after discharging the debts. In the end, let's summarize the key points. A contract by which one party promises to save the other from loss caused to that other party by the conduct of the promisor himself or the conduct of any other person is called a contract of indemnity. A contract to perform the promise or to discharge the liability of a third person in case of default by the third person is called a contract of guarantee. In a contract of guarantee, there are three parties. The person who is giving the guarantee, the promisor, he is called surety or guarantor. The person in respect of whose default the guarantee is being given, he is called the principal debtor, and the person to whom the guarantee is being given, he is the promisee in this contract and he is called the creditor. For a contract of guarantee, anything done or any promises made for the benefit of the principal debtor is a sufficient consideration for the guarantor for the surety for giving the guarantee. There are three different modes by which a guarantor, a surety, gets discharged from his liability. These modes have been discussed under section 133, 134 and 135 of the Contract Act. After discharge of his liability under the contract of guarantee, a surety shall step into the shoes of the creditor, shall get same rights as the creditor had against the debtor. And finally, a guarantee obtained by misrepresentation or concealment is invalid. So these are various provisions related with the contract of indemnity and contract of guarantee. Thank you.